What happens when a family can't agree on who should manage a loved one's care or their money? In today's episode, we're talking about what goes wrong when we don't plan for death or incapacity, and how even the most well-intentioned families can end up in court, spending more time fighting each other than supporting and caring for the person at the center of it all. The emotional cost is high, but the financial toll can be devastating, with legal fees draining the very funds meant to provide care. My guest is Sara Ecklein, a professional fiduciary in California who steps into that exact role, making critical decisions when no one else can or should. We'll talk about what a professional fiduciary actually does, what families often get wrong, and how a neutral third party can be the difference between peace and permanent damage to family relationships. Welcome to the Death Readiness Podcast. This is not your dad's estate planning podcast. I'm Jill Mastriani, former estate attorney, current realist, and your guide through wills, trusts, probate, and the conversations no one wants to have. If your Google search history includes, "Do I need a trust? What exactly is probate? And am I supposed to do something with mom's will?" You're in the right place. A couple of years ago, when I was visiting my dad, he came into the house looking confused. He had just picked up his mail and said, "I think someone sent me a lawsuit." I asked to take a look. What he'd actually received was a court order. As the president of a local organization, he was being instructed to send future invoices for one of the group's members, let's call him Mr. Smith, to a new person at a new address. Mr. Smith had become incapacitated. His wife had predeceased him, and his two children were in a legal battle to determine who should be making decisions on his behalf. There were also some allegations about how money had been mishandled and whether everyone involved had prioritized Mr. Smith's best interests. And that's how a very personal family matter ended up in my dad's mailbox. Because when these decisions get sorted out in court, they don't stay private. In situations like this, a neutral professional fiduciary like today's guest, Sara Ecklein, can offer stability, help families avoid courtroom battles, and focus on what really matters. Hi, Sara. Thanks so much for joining me today.
Jill, I'm so happy to be here. Thank you for having me.
So you're the first full-time professional fiduciary that I've had on the podcast. Could you first start by describing what a professional fiduciary is?
Yes. So I'm based in California, and, in California, we do things differently. So we have a small license, and we're a very small profession. There's about 900 actively licensed professional fiduciaries. The term fiduciary is really an umbrella term. So under that, I can act in different fiduciary roles. I really specialize in working with clients privately. So what that means in California is I'm basically a professional trustee, and I also can act as an agent either under the durable power of attorney for finance or also in the advanced healthcare directive and be someone's healthcare decision maker.
And for anyone who might not be familiar with these terms, let me break them down quickly. An agent under a durable power of attorney for finances is the person you choose to step in and handle your money if you can't. That means paying your bills, managing your accounts, handling investments, filing tax returns, basically steps into your financial shoes. Then there's the agent under a durable power of attorney for healthcare. This is the person who makes medical decisions for you if you're not able to speak for yourself. They're the one talking to doctors, signing off on treatments, and making sure your care reflects what you want. And a professional trustee is either an individual like Sara or a business that manages the money and property in a trust. They follow the rules set forth in the trust agreement, make sure the assets are invested, bills are paid, and distributions go out to the right people for the right reasons at the right times. An agent serving under a power of attorney as well as a professional trustee are all referred to as fiduciaries. Sara, as a professional fiduciary, serves in each of these roles. So, Sara, I've heard you describe yourself not just as a professional fiduciary, but as a mindful fiduciary.
Yeah, well, mindfulness is, I would say, the bedrock of my life and how I do this work. It's definitely my approach and what brings me here. Meditation is, for most days, my daily practice. Of course, some days it goes out the window, but
Well, I hear the word mindfulness a lot, and I do agree that it's so important. I've never been one to meditate. And in fact, I remember a distinct memory with my mother sitting on the beach right before I went into kindergarten. And she wanted us to meditate together.
oh,
And I told her I couldn't because I was too excited about kindergarten. And and since then, I've still been unable to meditate, but I have seen other people really, really benefit from it. And I would imagine that's really important for you to have that grounding, considering the somewhat intense nature of the work that you do.
yeah. And I think it's really also speaks to my approach. I find that the profession as a whole, and I'm going to speak to not only just professional fiduciaries in the state of California, but really anyone that's doing this work, whether it's a bank officer, at a corporate trustee's office, professional fiduciary. In a lot of states, attorneys or CPAs will be doing this work. I think the profession as a whole, or this work as a whole, really leads just with kind of the credentials. I think when most people think of a trustee or executor, it's very buttoned up, very stoic.
Yes, I agree.
My experience of this work, it has connected me to our humanity more than you can imagine. I think that the money, the assets, the administrative part of this work is really, it's not hard work. I would say that's the easiest, simplest piece, right, of executing that. It also helps. I'm a total type A recovering perfectionist. And, one of those people, my ducks are in a row. I'm very organized. I always have been. But really, the harder piece, and I think what's really needed to serve families in this way, is to be this, neutral party and neutral presence, no attachment to outcome. That is a practice that I've just had to kind of work on through the course of my career. Meeting people with presence, with empathy, with compassion. I don't think that most professionals are really focused on that.
And I think it is so important, especially in your work, because if someone is needing an agent under, a financial power of attorney or an advance directive, that's not a good situation for the person who's requiring that service. Something has happened generally, whether it's a mental decline or an accident that's causing them to no longer be able to make those decisions for themselves. And that's difficult. It's a difficult time.
It is. And I find that even for the families, right, we know the sad statistic that 1 in 3 people are actually getting their estate plan done in the United States. So even those that plan, I think that the denial of death is still, very present for us all, right? We live in a death denying culture. We're kind of on this endless need of being productive. We want the new, the flashy, the sexy, and planning for our death, working on our estate plan, it doesn't check any of those boxes, right?
Well, let's make death readiness sexy again, Sara.
Yeah, me and you. I love it.
The two of us. That's our goal for this
I love
year.
it. I'll make a shirt.
Thinking about preparing for death or the care or services you might need, that sort of image that you have in your mind of a person who's probably buttoned up and rather stoic, as you just said, do you think that's a misconception that many people come to you with, is that you are that person that they might not be able to relate to very well, that it's a very superficial professional relationship?
That's interesting. I haven't reflected on that. I think historically that's what it has been, more so, right?
Okay.
Historically, I think that who sits in this position. If it's a professional, it's usually a bank. To me, that doesn't feel very warm or approachable, right? It's people cutting checks. You may have a point person you're assigned to that's going to change over the years. But is that relationship really built? I don't know. Maybe.
Can you give an example then of a support that you've provided to an individual where your services are much more than cutting checks? And I would imagine even serving as an agent under a healthcare advance directive, that probably would be a situation where you would have a very intimate understanding of who this person is and what their desires are.
Yeah. How I serve clients, it's kind of a whole rainbow and a whole spectrum of how I serve, right? Sometimes I'm wearing just one hat, and usually if I'm just wearing one hat, it's the hat of the trustee. And a lot of times I'm wearing multiple hats. So I'm wearing the hat of the trustee, also as a power of attorney for finance, and sometimes also the healthcare piece. So, of course, in the healthcare piece, I think most people can see where there's going to be a lot more like closeness, in-person meetings, knowing what's going on with, my client medically, checking in on their well-being, their quality of life.
What types of questions might you ask someone before, in the example of serving under a healthcare advance directive, what would you generally need to know in addition to, I guess, what might be in the form that they fill out?
Do you know the 5 wishes document?
I do. And for anyone who's not familiar with 5 wishes, it's a document that helps spell out your care preferences in plain language. It covers 5 key areas, the 5 wishes: who you want making your healthcare decisions if you can't, what kind of medical treatment you want and don't want, how you wish to be kept comfortable, how you want people to treat you, and what you want your loved ones to know. I'll include a link in the show notes to the 5 Wishes website.
I think it's a wonderful exercise. It's really getting, and what I say for my clients where I am serving in successor roles. So I have my whole kind of intake and onboarding clients when I work with clients, again, proactively in the planning phase. They don't need immediate services, but I'm being named in those successor roles.
So you're appointed to serve in the future when whoever maybe is currently serving isn't able to, or whenever there is an incapacity potentially later on.
Yeah. So I'm being named, sometimes I have a lot of single ladies, never married, no kids. And then also for my couples where they're beginning to plan for the surviving spouse and who's going to support them as they age. I can be named as backup, planning for kind of all of those scenarios of, who the surviving spouse would be. How I describe my intake documents, and most people don't need to work with a professional fiduciary. So that's where I do like to direct people to 5 wishes because that's something that's available to everyone. Our estate plan I see is like really kind of the framework. That's what's giving me or will give me the legal authority to, step in whatever fiduciary capacity I'm serving. But my intake forms really are kind of coloring in the lines with more detail. So asking questions like, what are your interests and hobbies? Like, who are you as a person? What are your favorite foods? Paint a picture of what your life looks like. I find that I can do a pretty darn good job at advocating for you, of acting, as your fiduciary when the time comes, if I know you as a person. But if we've never met, if I don't know who you are, we haven't built that relationship years before, and now you lack capacity and we're beginning to work alongside together that way, it's doing your best guess. Of course, you can meet with family, but a lot of times with those kind of scenarios, this person lacks community, they lack support, they lack the family and the relationships, or maybe they're the only one left surviving. And so there's not really anyone to ask. And now I'm working alongside someone who lacks capacity, that can't really communicate what their wishes are.
How do you serve a client who is incapacitated and you've not met that person prior to whatever has rendered that person unable to make decisions for themselves?
That's a good question. I mean, you do your best, right? You do your best. And building the relationship, again, long before, it's going to be a much different way of serving the client.
When you agree to serve as a fiduciary in some capacity, whether as a trustee or an agent under a power of attorney, and the trigger for you to serve is an individual's incapacity, how do you prepare to serve that person in the future?
Well, this is where I find the profession as a whole really has two camps. Historically, more professional fiduciaries don't build that relationship proactively. For me, I have a different approach. I think that we can build that relationship. I can gather information up front. A lot of times my intake forms were inspired from those cases where I was working with clients that I didn't know or had to fill shoes immediately. And you're like, oh gosh, I don't know. Our pets, for example, that's a huge one.
I'll link to the pet information sheet in the show notes for anybody who wants to fill that out.
Yeah. Well, and that, why is that? Why do I gather that information? Well, because, for many years, when I worked for other fiduciary agencies before starting my practice, and they provided conservatorship services, I was working alongside conservatees and, you try your best, but I don't know what vet they went to and they don't remember. So now we're starting from scratch and we don't have the medical records and, we looked everywhere in the house, but if you can't kind of find that information, then what are you left to? Well, we're going to start care for the pet at somewhere new.
I'm stepping outside my conversation with Sara for a moment to clarify a term you heard Sara mention, conservatee. A conservatee is an adult who can't make decisions for themselves and did not, before becoming incapacitated, name someone, or at least someone who's currently able to act on their behalf, like through a power of attorney for finances or healthcare. When that happens, the court steps in and appoints someone, maybe a family member, maybe a professional fiduciary like Sara, to make decisions for them. And to show you what this can look like in real life, I want to share a recent guardianship case here in Michigan, where I live. For our purposes, let's treat guardianship and conservatorship as meaning roughly the same thing. This case is called In Re Guardianship of AMS. I'll link to it in the show notes. I don't know AMS's real name, so I'll call her Anne. Anne needed a guardian. Her two daughters, Teresa and Kristen, each filed petitions with the probate court asking to be appointed. But the court didn't choose either of them. It appointed Anne's husband, Thomas. After his appointment, Thomas moved Anne into a nursing facility. Not long after, Teresa, one of Anne's daughters, asked the court to either remove Thomas or modify Thomas's role. Teresa complained that Thomas wasn't letting Anne's family visit her. The court brought in a guardian ad litem, or GAL. A GAL is someone who acts as the eyes and ears of the court. The GAL reported that Thomas wasn't responding to communication, hadn't cooperated during earlier proceedings, and that Anne wanted to see her daughters. The probate court removed Thomas and appointed a public guardian instead. You might agree with that decision, you might not, but it didn't end there. Thomas appealed, and he won. Why? Because the probate court hadn't followed the rules. The notice it gave Thomas and Anne said the hearing was to modify the guardianship, not remove Thomas altogether. And that matters. Also, before removing a guardian, the court has to conduct what's called a suitability analysis, not just for Thomas, but for each person who might be qualified to serve. In Michigan, like many states, the law lays out an order of preference. Spouses come first, then adult children, who are treated equally in terms of priority. So even if Thomas wasn't the right choice to be Anne's guardian, the court needed to consider both Teresa and Kristen, Anne's daughters, before appointing the public guardian. Let's pause for a second. This is a real family, a real woman, Anne, who was ill and vulnerable. And now her private life is on the public record. Legal fees are piling up, emotions are running high, and family relationships may be permanently damaged. Just imagine, maybe Teresa and Kristen are doing everything they can to protect their mom. Maybe they've dipped into their own savings to fund the legal fight. Maybe they weren't on great terms to begin with. So, how's that going now? And Thomas, maybe he loves his wife deeply. Maybe he's doing his best. Maybe he just wanted peace and privacy. And now his decisions are being challenged in open court. Is anyone right? Is anyone wrong? Honestly, we can't know. But we do know this: Anne is suffering, and so is her family. And everyone's paying for it financially, emotionally, relationally. And now I'm here talking about it on a podcast. I'm talking about this because stories like this are not rare. And they're not just sad, they're expensive. It's not unusual for a contested conservatorship case to cost more than $100,000 in legal fees. That's someone's retirement or all the money that could have paid for care. Could this have gone differently? Absolutely. That's where professional fiduciaries come in, neutral third parties who can help families avoid these kinds of breakdowns, who can do what's best for the person at the center of the story without getting tangled in the family's emotional crossfire. By the way, under Michigan law, people like guardians ad litem, conservators, guardians, and fiduciaries are entitled to reasonable compensation from the ward's estate. Here, the ward is Anne. And often, the probate court will award reasonable attorney's fees to the appointed guardian for obtaining the guardianship. Nobody's working for free. And sometimes paying a neutral party up front saves everyone from a much more expensive disaster later. Before moving on, I want to shout out to Megan Miracle, a Michigan estate planning attorney, for clarifying some of the nuances of Michigan's guardianship laws for me. And if you're curious whether a professional fiduciary could be a good fit for your family, I've got a free quiz for that. Just go to deathreadiness.com/pro, P-R-O. Answer 10 quick multiple choice questions and learn whether hiring a neutral third party might be the next best step to protect your family. That's deathreadiness.com/pro, P-R-O. I stepped out of my conversation with Sara to share this story about Anne, Thomas, Teresa, and Kristen, because it gives some context for the kind of work that she does. In the next part of our conversation, we're talking about how Sara serves as trustee for special needs trusts and how being that neutral third party allows her to move things forward in a way families often can't do on their own. Too often, she's brought in after relationships have fallen apart. Sara encourages us to consider how seeking support proactively could be the most important part of your legacy. A lot of the work you do is serving as trustee of a special needs trust. So that population of individuals who need special needs trust, they have some sort of disability that causes them to need government assistance or government benefits. And that type of trust is a bit complicated to administer, so a bit more difficult for your lay person to try to administer, such as a family member. Have you seen situations where maybe a family member is named as trustee, gets in over their head, and maybe the relationship is sullied between the beneficiary of the special needs trust and the beneficiary's sibling who maybe didn't even want that job in the first place?
Oh, yeah. I mean, that is, I would say, a handful of what I consider my active cases. So this is like, I'm not being named in successor roles. These are my current beneficiaries. I'm administering these special needs trusts, or even sometimes it's not always a special needs trust, it's just a trust. And I think that that's a big piece of when a professional gets involved. That's also a big piece of why I love having conversations like this, is reaching people upstream proactively. Sometimes I feel like, as professionals, and what I hear kind of with estate planning attorneys, the focus can be too much of just staying out of probate, at least in California.
Mm-hmm.
And while that's a piece, I don't think that's everything. And I can say downstream, administering trusts and estates, and I've administered hundreds over the decade that I've been doing this work. We might have a trust where it never went to court. It was never litigated. So I guess, in some people's mind, that might be a quote unquote success case. Things were done according to the documents, but, now the relationship's ruined.
And where you said there's been no litigation, it's not been through the courts. Is that the only way that a trust can sort of be questioned or the fiduciaries can be held accountable? Or are there separate trust police somewhere out there who are overseeing the situation?
Well, that's again where it's going to really depend. I mean, kind of the worst case scenario, yeah, things do wind up in court. You could have a trust protector or a trust committee where there's some oversight of the trustee. I think that's one of the benefits. If you are in California, we do have licensing. I believe we're 1 in 2 states that does have a license for this work.
What I was thinking was someone who's choosing a family member to serve as trustee might think, okay, well, if they do a bad job, they'll get kicked out. Well, there's no one there to kick them out, right? Especially if the beneficiary has special needs. It would need to be someone bringing a cause of action in a court. And you talked about trust protectors and trust committees, and those could be other individuals generally who might have certain powers, for example, to remove and replace a trustee. But that's not some sort of governmental oversight. That would be something that you're putting into your trust agreement that's specific to you.
Yeah, that's right. And that's where, again, it's going to really kind of depend document to document. So that's where, again, it's going to matter, partnering with an estate planning attorney in your local state that can advise the best course. But in California, and also because I deal a lot with special needs trusts, I work with a lot of trust protectors. And so a lot of times it's, kind of just going back to the example of your family where, you could be the trust protector for your brother's trust, not burdened with the responsibility of managing your brother's special needs trust, and have a neutral party and a professional administering the trust. A, it's a lot of work, but B, it's hard.
You might not have heard the term trust protector before. And that's okay. It's not something that comes up in everyday conversation. A trust protector is typically someone who's given specific powers to oversee a trust without actually managing it day to day. In this kind of situation, a trust protector acts more like a watchdog than a manager. For example, instead of naming a sibling as the trustee, which can put them in a tough situation with the beneficiary, parents might name that sibling as the trust protector instead. That way, the sibling isn't the one saying yes or no to every request from the beneficiary for money. They're not in the middle of every decision. But if something goes wrong, say the trustee isn't acting in the best interests of the beneficiary, the trust protector can step in. The trust protector might have the authority to remove the trustee and appoint someone new without being directly involved in the daily administration of the trust.
That changes the dynamic because there is a power differential. Let's be honest, right? You're in control of these funds. You say yes or no. And so when you add that extra layer of being siblings, that's where tensions really can run high. And then add a layer of grief, right? You just lost your parents. And that is where I think families can really fall apart. So I do have cases where I'm now administering the special needs trust. I took over from a sibling and they don't talk anymore.
And that's really difficult because I think you said before that a lot of times in California, the focus is on avoiding probate. And that's true everywhere. I think, at least in everyone's mind, whether or not probate in a particular state is problematic. Everyone kind of has this general idea that probate is bad. And it isn't always bad, but you're also need to be thinking about your larger legacy, right? And if you're naming a family member as trustee, often a sibling, I could see that being the most problematic. And in the situation you just described, because of the dynamic between a trustee and a beneficiary and a sibling, they're no longer speaking. And that's not the legacy that parents want to leave. Maybe they left all the money they had and the money is totally sufficient, but they forgot about the piece about making sure that their kids could still have the relationship that they had before their parents died.
Yeah, I mean, those are the hard conversations that I've had with my clients where holidays have changed now. We don't talk anymore. We're no longer, sitting down at, Thanksgiving where this was an annual tradition. And I will say I have a handful of cases like that. It's very sad. So that's where I think how we approach this work, where we're coming from, it really matters. That's really what I speak to and why my business calls itself a mindful fiduciary agency, because it's really acknowledging that emotional piece. I think most people come to for those that do plan, they really are coming to estate planning from this place of worry, fear, also just not knowing, being confused. And we could really, I think, again, flip it up on its head and instead see it and connect to the power that it has, which it really is leaving a legacy of love. If we're intentional, if we really, in the present moment, connect to our values, our wishes, what matters most to us, and then partnering, with the right team. So I think that's, again, also working with an attorney that you like and trust them, but you could also feel that you can ask the stupid question. I love what you do. I love that you have a podcast and that you're a practicing attorney. I can't remember in what state. Sorry.
Well, I'm not currently practicing. I'm licensed in Tennessee, but I'm not practicing right now.
I love that because it's also like I think when I say we, like, I'm saying this not only as a professional fiduciary, but as a mother. Like when we plan, we want to surround ourselves with like collaborators, thought partners. Like let's try to sit down, be intentional with this plan, and hopefully have this plan succeed. And for me, becoming a mother is what has just deepened my love for the work that I do, and seeing where this work has the power to transform not just our life and her life, but it sets up the whole family system and future generations for being right in relationship with ourselves, with the truth that, there's this denial of death, and we have to be courageous and willing to face that, our own mortality, being courageous to talk about money and our assets, being courageous enough to have the difficult conversations with our loved ones.
So let's move then. That's a good segue to death readiness, making it sexy again with Sara Ecklein and Jill Mastriani. But as a California fiduciary, your business has to be in your individual name. So what happens, Sara, when you die professionally? What happens to all those matters that you have where you're serving as trustee or an agent under a power of attorney?
Yeah, well, that's a great question. This is where I'm a big proponent. I hope that over the course of my career, we will have the ability to establish professional corporations. Right now, like you just said, and I've said before, that
there would be more than one of you under the same umbrella.
Yeah, and it could provide like kind of that continuity, because obviously as an individual, I run into those same risks that anyone does, death, incapacity. So with clients in the planning phase, every attorney has their kind of workaround of how to kind of navigate that challenge, whether it's naming, sometimes it's having your choice A, B, and C. So you have your first person, your second, and your third, just in the event that no one can act.
So it might be that, okay, Sara Ecklein is named as trustee in the event of her death or incapacity, or if she no longer wishes to serve, then I appoint Joe Smith to serve as trustee.
That's right. Then also kind of what we talked about before with like a trust protector, where here's this other person at least what I'm used to seeing, it's a non-professional, it's a family member. They would also have the ability to appoint a professional. Someone could have that power. Sometimes I've even seen the estate planning attorney themselves having that ability to name a professional in the event of vacancy. If the trust doesn't mention it, that's where it's going to be going to court. So,
right. And you're
right?
going to be looking at the statute, right? Each state is going to have some sort of trust code that says if there's a vacancy in the trusteeship, like let's say Sara is appointed, Sara is no longer able to serve by whatever reason, then there's a vacancy and the trust doesn't say what to do, you look to your state's law and it will say who has the power to name the next trustee. And often it's beneficiary, or if there's a reason a beneficiary cannot name, the last resort is often to have the court name a successor trustee.
Yep. So that's just, again, working with clients in the planning phase, right? Like if something happened, but I'm not in those shoes yet, that's kind of the workaround. I would say this is also where our estate planning documents are living documents, and we should be updating them, as time goes on. Laws change, tax codes change, and also the people that you have as your proxies, that's going to likely change over the years. For my active cases, so this is also where it depends. So what hat am I wearing? Most of my cases, most of the hats that I'm wearing the hat of trustee. Well, you've got to go to the document. Is there someone named after me? Who has the ability to appoint? We can set up a practice administrator where I basically nominate in the event of my death or incapacity. These are other professional fiduciaries that would basically be kind of handing off and sending off kind of the cases to wherever they go.
Is that under California law?
Yes.
Okay.
Yeah. And that's I think it passed in 2023. So that's also something that, I've set up.
How would somebody know, okay, you're administering a trust. How would somebody know what assets are in the trust? Sara's gone. And now we've got a trustee that has a successor trustee named. So Joe Smith needs to start administering this trust. Mm-hmm. How does Joe Smith get the information that you had?
Well, that's exactly kind of the purpose of practice administrator, where they would be like basically all the files for each case would be sent to the appropriate person.
I see.
That's actually been a huge piece the last year or year and a half that I've been working on internally with my practice, setting up my practice administrator documents, and then also now kind of doing a whole emergency handbook just in the event that something does happen to me.
Sara, can you tell us, I know we've talked a lot about you being a professional fiduciary, but you're also a podcast host. Can you tell us about your podcast, when you started it, what it's about, what it's called?
Yeah. So the podcast is called The Legacy of Love, and I launched the end of October 2024. I love it. I mean, podcasting, reason why I'm here, I think meeting people proactively is a large part of what kind of connected me to, this mission, this movement, which connecting with you has kind of been part of that journey. The more that I talk with other professionals and expand my network outside of California, I guess have hope that things will change. I think that we're going to be kind of forced to reconcile where there's just these huge gaps with baby boomers aging. I mean, there's just so much.
Do you mean gaps in their understanding or knowledge of what is required in an estate administration, or what exactly gaps?
Just even gaps in care and service, and also in planning. And I think that so much of what, and why I wanted to launch the podcast is really this love of working with clients proactively. But I also acknowledge, like, most people aren't going to need to work with a professional fiduciary, right?
Right. And you're not just talking about what it's like to be a professional fiduciary on your podcast. What types of people are you talking to?
So I definitely have plenty of conversations with estate planning attorneys. I brought in financial advisors, people focus on aging and care. I've brought in like some people that are more like therapists talking about family systems or birth order.
Right.
So I've kind of expanded, and this is, whether, your listener is just an interested, non-professional party or also a professional. I think we're kind of at this time where we need to expand how we're thinking about our legacy. Like this is way more than just getting our estate planning documents done. I mean, yes, those do need to be done. And yes, that's so important. And that's a key piece in, a successful plan and successful families. But really, our legacy is, yes, what we leave, but it's also how we live. So the more that I'm having these conversations, I'm realizing what this comes down to is our identity and who we're choosing to be. I think so much of the podcast too is not only wearing the hat of a professional fiduciary, but also wearing the hat of a mother, and I'm learning and evolving alongside listeners.
Well, I think that you and I would likely agree that the different aspects of estate planning and end of life care, legacy planning, it's been very siloed. You have the estate planner drafting the documents, but if you're wondering, okay, what are my burial options? Well, the estate planning attorney doesn't even know who to send you to. And you're, as just the layperson who's not in this industry, also has no idea where to begin. And I think that these podcasts provide a way to sort of open the curtain and see what's behind these different areas that can be scary on our own to figure out. And you are able on the podcast to open up those conversations and educate and maybe make people more comfortable with what sort of options are available depending on, the type of death adjacent situation that they might encounter.
Yeah. I mean, my thought, right, it's the one guarantee in life that we're all going to die.
Right.
And yet most of us don't plan for this.
Correct.
And so if we're kind of going through the motions, asleep at the wheel, not willing to look at this part of our life and tend to our life, we know what that's going to look like, right? I think me and you both have seen those cases, worked with those cases. And I think most of us, even just personally, have seen, families feuding in court. Maybe there's also just a mess and people not really knowing where assets are and what's part of the estate.
And it gets so expensive so quickly.
It really, I mean, I know. When you see kind of compare the difference, it's significant. But at least in California, it's like the executor is getting a percentage. Also, the attorney is, and it's very high. And it's also not private. It's going through court.
Correct. And when you say the executor is getting a percentage, I want to clarify that some states permit the executor's compensation for serving as executor to be a percentage of the value of the probate assets that the executor administers. And probate assets are those assets that are governed by a person's will. Generally, if you own an asset in your individual name and there is not a designated beneficiary or payable on death or transfer on death designation, then that asset will be a probate asset and administered according to the terms of your will. I won't elaborate on this now, but if you want to learn more about wills and probate assets, check out my Do You Need a Will video available at deathreadiness.com/will, WILL. That's deathreadiness.com/will, WILL. Assets administered according to the terms of your will go through a court-supervised process known as probate.
And it's really slow.
And that's even if you're not fighting about it.
Yeah.
You start fighting about it and you don't know where assets are, then that expense multiplies very quickly.
Oh, yeah. Yeah, with extraordinary fees. But I think what's also, even more harmful and where it's like this can just ruin families when it's like no longer, the siblings are talking, and the whole family is shattered. And that's just such a disservice. So I think that the more that we can lean in to the discomfort, be willing to have the hard conversations, to look at our mortality, And also for the professionals listening, that I think that the more that we're connecting with people just from our humanity, the more that we can serve better. Like, we're not going to be able to reach people by just scaring them into this.
Right.
And that's what I'm really learning, I mean, that's never been my approach of scaring people into it, but of really trying to understand, okay, why is it that we're not planning? And I think it comes so much of us as a culture collectively. I think we need to reconcile this, and we can do so much better.
Well, I think part of it is simply that everyone is so busy, especially the people who everyone else assumes is in charge of the family's planning, which is likely the same person who's in charge of carpool and dinners.
Yes.
And that can all get to be...
Jill, I get it. I have a toddler.
Well, Sara, thank you so much for joining me today. This has been a great conversation.
Oh, thanks so much for having me.
You can listen to Sara's podcast, The Legacy of Love, wherever you get your podcasts. If you're in California and think Sara might be the right fit to serve your family, the best next step is to talk with your estate planning attorney. Your attorney can help determine whether bringing in a professional fiduciary makes sense for your situation. You can also learn more about Sara and her work at trustandhonor.co. trustandhonor.co. I'll include a link in the show notes. We don't talk about death, money, or care until it's urgent. Sharing this episode might be the nudge someone needs to start planning before it's too late. If you think someone you know could benefit from this episode, please share it. If this episode hit home and you're wondering if your family could use a professional fiduciary, take the free quiz at deathreadiness.com/pro, P-R-O. That's deathreadiness.com/pro, P-R-O. The answer might save you from a 6-figure fight. The link's in the show notes, deathreadiness.com/pro, P-R-O. If your parent died tomorrow, would you be expected to front the funeral costs? Would you know what your parent wanted? Would you feel pressured to spend big out of guilt? Next week, I'm talking with funeral planning expert Jamie Sarche to talk about what really happens when a funeral isn't prepaid, the family drama, the financial minefield, and the emotional toll no one talks about. Because grief is hard enough. Paying for it shouldn't break you. This is Death Readiness, real, messy, and yours to own. I'm Jill Mastriani, and I'm here to help you sort through it, especially when you don't know where to start.
Hi, I'm April, Jill's daughter. Thanks for listening to the Death Readiness Podcast. While my mom is an attorney, she's not your attorney. The Death Readiness Podcast is for educational and entertainment purposes only. It does not provide legal advice. For legal guidance tailored to your unique situation, consult with a licensed attorney in your state. To learn more about the services my mom offers, visit deathreadiness.com.